As companies enjoy the freedom and flexibility of the cloud, they must also be aware that major activities of cybercrime have moved from the personal computers of end users to servers in the cloud. A multi-tenant environment with a single flawed application from one of the clients puts the entire cloud infrastructure at risk. History has witnessed a number of cases of data breach, financial frauds, identity thefts, and cloud abuse resulting in the loss of money, reputation, and brand power for many organizations. With so much riding on data security in the cloud, the legal aspects for safe cloud computing must be significantly addressed through due diligence of the cloud service provider and through mutually agreed contracts. Protection of information is the first and the most important clause that needs to be added to the contract. Moving data into the cloud means that the data will move outside of the direct control of the organization and are vulnerable to hacking attacks or security breach. Cloud service providers need to be aware of their privacy and data security obligations while handling confidential customer data. The contract should also enable organizations to do periodic audits to ensure that the contractual obligations are being followed rigorously by the cloud service provider. It is possible that data could be permanently lost by a cloud computing services provider in a number of circumstances such as technical or operator error, as well as fire or other disasters. Similarly, there is always the risk of misuse of data by rogue employees of the provider or compromise by external parties. The probability of such problems can be minimized by the provider ensuring off-site data backup, proper technical and security training, and hardware maintenance. It is important for an organization to have necessary clauses included on how to address data loss or misuse in its agreement with the cloud service provider. Then comes the indemnity clause. Indemnity is a legally binding promise by which one party undertakes to accept the risk or loss or damage another party may suffer. Usually in cloud computing contracts or service agreements, the organization will require an indemnity from the cloud service provider. Another usual clause is related to the performance management of the cloud solution as such. A cloud solution offered by a cloud service provider should be robust enough to handle huge traffic and requests, have high uptime, periodic backup mechanism, ability to scale up and scale down depending on the traffic, and should be energy efficient. All of these performance-related points are to be mutually agreed and included in the service level agreement or the contract. If the cloud solution fails to achieve one or many of the terms, there should be a penalty that must be levied to the cloud service provider. Another important clause would be of business continuity and disaster recovery management. Organizations should include necessary protections in their contracts to ensure suitable backup mechanism in place when there is a disaster or an emergency. This helps the business continue without much disruptions due to emergencies. Default termination clauses should be included if in case the service provider fails to provide services as agreed, or if the cloud solution as such is not performing up to the expectation of the organization. Some organizations also include a clause which provides them rights to terminate a cloud service provider when there is an acquisition or merger of the organization with other companies. In such situations, the cloud service provider is usually entitled to get a termination fee as compensation. The termination clause should also include provisions for settlement of disputes through suitable arbitrations. Apart from the above key clauses, there are a lot more points that would be included based on the unique requirements of the organization. The contract is first negotiated well between the organization and the cloud service provider and is then legalized by involving a law firm. That's a brief overview of legal issues that are to be considered in cloud computing.